Ashley Merchant should get all of the kudos. She dug into the details. She did the motions. She did the subpoenas. She did an amazing job. She's the reason why I think they're going to be thrown off the case. Mr. Sato was great at cross-examining the witnesses and making them look like liars. And Mr. McDougall knocked it out of the park with a closing argument that should be taught in law schools. Fortunately, Mr. Abato, if I was a law school professor, I would probably be using this video to teach trial lawyers how not to do a closing. But a masterclass in learning what to do and what not to do, and how you can enjoy a message and how you can hate a message. Good day again, ladies and gentlemen. We are going to enjoy an actual masterclass in the art of closing. For any of you who want to be a lawyer or who are lawyers and you want to learn about how to do a closing argument and how to not do a closing argument, we are going to cover that in this video as we go deeper into the Fani Willis case. I'm so happy that I delayed doing the video on the closing arguments because I was able to watch the Senate hearing where Ashley Merchant is essentially setting fire to the whole district attorney's office. I think she's going to bring down that whole institution in an Aaron Brockovich moment as she testifies live to the Senate of Georgia and can tell her story, which she tells much better than she's able to get other people to tell a story. That's a whole other ballgame. But when it comes to closing arguments, you can see in this particular case, the good, the average, the bad, and the ugly. There's a dark horse who came out of nowhere who is now my favorite lawyer. I'm going to try to get on my podcast, and nobody was talking about him. I think most of the commentators didn't really pick up on him. Everybody is in the Mr. Sato fan club. Good lawyer. However, one particular lawyer knocked it out of the park, and we're going to watch him in action. I'm going to tell you why it's amazing. And then I hope that you sit with me, bring some chips, popcorn, whatever it is. And we're going to quickly go through an actual dumpster fire. A district attorney's office, the state attorney, do what is to me the worst closing argument I've ever seen in my legal career. And we have here one of the biggest cases in the country. And we get to watch live the self-destruction of a nervous attorney who does the worst closing argument I've ever seen. I'm going to highlight a couple of reasons why it was so bad. So hopefully we can all learn what not to do if we're making a closing argument in court, or if you're just trying to summarize your argument in business or life. This guy is the case of what not to do. Let's get right at it. All right, we'll start with just watching Fani Willis coming into the courtroom. She is the main object of all of these proceedings, and we're just going to look at the body language as she comes in and sits beside Mr. Abato, who's going to do the state's closing argument. Saying hello to family. So far, it looks kind of normal, but you see Mr. Abato, who works for her and is working for her on this case, no eye contact whatsoever. Just typing and grinding his jaw. Probably has no molars left. You can see very stressed individual with the mouth there. He's like, what the hell am I going to do here? Ms. Willis drops her pen and he picks it up. Doesn't look at her. What that tells you is that although he's not looking at her, he is very sensitive to her body language, because he looked like he was writing notes. She drops the pen and he immediately picks it up. There is huge tension between these people. Look at Ms. Willis's eyes here, right? This is the eyes of somebody who doesn't want to be there, who's angry. She's not blinking, and not blinking is kind of when you're in this state of what's going to happen next. You're just kind of like looking around everywhere. I can see anger, a lot of hidden anxiety, and looking for an ally here. But the most interesting point is the dynamic between her and her subordinate, and apparently her knight in shining armor. And we'll see how well that goes later. Like no blinking. Then finds a friend. Trying to be confident. So Ms. Willis looks nervous. Mr. Abato looks terrified. Looks like he'd rather be anywhere else. We've heard that she's been yelling at him during the whole process. And before we get into the closing arguments, I want to talk a little bit about the updates so far. As I said, Ms. Merchant's in front of the Georgia Senate testifying right now, I think bringing down the DA's office. You can guarantee that the judge in this case, having adjourned for 2 weeks to write a decision, is watching her testimony live, and to see her tell the story is way more compelling than to hear her try to get evidence out from witnesses that are trying to protect people. We also heard this week that another district attorney from an office beside Fulton County has come forward and given evidence that shows Terrence and Fani were lying, that she knew that they were talking about they're coming for us, don't say anything. This is getting very close to obstruction of justice. I had a lot of my subscribers ask me, can they reopen the case? Judges generally don't want to reopen the case because they want to get things done. However, when somebody as high profile as a prosecutor comes forward and says, look, I've got evidence that's relevant to your determination, it might show one of the witnesses to be a liar, I would bet that the judge reopens the case to hear it, because if he doesn't, it's just almost an automatic ground of appeal. So whatever if his ruling goes against the defendants in this case, they have an automatic ground of appeal because they can say we have new evidence that is critical to witness credibility. So I think he's going to reopen the case. We're going to see another witness come forward and show Willis, Wade, and Bradley to be liars. This is crazy. You couldn't write a soap opera like this. If I presented this script to a movie production company, they'd say this is not believable. There's no way anybody would watch this. And it's happening right before our eyes. What I think is relevant is the nature of power. You can have a lot of power behind you and everybody thinks that you're legit. But as you slowly lose your credibility, you can see the walls are crumbling around Fani Willis. She was very arrogant. She was sloppy. And the more people watch and learn about this case, the less and less support she has. I'll give you a good example. I have an amazing friend who's a lawyer in Virginia. Quite a liberal lady, but she does wonderful work for the community, for victims of assault and car accidents. And when I sent her the video of Fani Willis, she's like, I don't want to see it. Trump's a bastard. I'm like, my friend, just watch this and tell me what you think. And she sends me an email and she goes, Phillip, whatever you do, make sure your video of Fani Willis doesn't get to the judge. So it shows when somebody is so liberal and wants Trump to be destroyed at all costs, and they actually watch this, they can't support Fani Willis. It's too bad. Like, you really have to be insane to think that this looks good. And I can only imagine what's going on in the Biden White House with the people who were working with this office to try to get this prosecution done before the election as a way to get Trump off of the case. Somebody should be getting fired for allowing this to get out of control. One of the handlers totally dropped the ball, or as we would say in the military, SHIT the bed on this one. Terrence lying, not sure how he's going to get out of this without ever being charged. Can't see how there's not going to be an obstruction of justice charge that comes out of this, and these lawyers losing their licenses at some point for misleading the court. The question that I'm left with too is Emily Cross. Emily Cross was a prosecutor who was respected. She disappeared off the case soon after it started. She was providing some bills to the court, to the county for this case, and her bills were very reasonable. Most lawyers, when they put in a bill for time, round to the nearest 10 minutes because clients will look at it and say, hey, you're screwing me over. That was a 5-minute call. You just billed me 20 minutes for it. It's the nature of the hourly billing. I could do a whole video on why hourly billing provides no value to clients and it incentivizes corruption. That's another story. But Emily Cross, who was a respected attorney, prosecutor on this case, has disappeared. I believe she's jumped ship and she's like, I'm not going down with these people. I did my job well. She's gone. Everybody has left. All the rats have left this ship and the world is closing in on these individuals. So we come to the part where now that all the evidence is given, we're going to do closing arguments. For those of you who don't know, closing argument is your final time as an attorney to convince the fact finder, which is either a judge or a jury, that your case should be successful. So you have opening statements where you outline the evidence that's going to be heard. You call your case. The other side calls their case. You cross-examine their witnesses. And then when you hear a judge say, we'll leave that for argument, that's for the closing statement. So in this case, all of the attorneys on the defense side, which we'll just call it kind of the Trump side, gave closing arguments. And I'm not going to go over all of them. Ms. Merchant did a good job on her closing argument. She covered the evidence as best she could still work on refining the persuasive advocacy. Like when you look at the movies that give us tingles, there is usually that element of on closing, you evoke something that makes somebody, like when I look at closing argument, I want to tell a story that makes the judge or jury feel passionate about finding for my side, feel like it's for justice. And too many lawyers just get up there and say, Your Honor, in closing, I'll summarize the evidence. And I'd rather stick a pencil in my eye than listen to somebody tell me the evidence that we all just heard over 2 weeks. I don't know why lawyers do it. I think it's because they're generally timid. And keep in mind, to get in law school is very difficult. Trial lawyering is an element of theater and strategy. It's not just book smarts. And that's where you can see a lot of lawyers fall down. They think they're trial lawyers. They're really book smart, but they don't understand theater and strategy and thinking on their feet. Ms. Merchant was good. Everybody loves Sato, Trump's lawyer. I think he's an aggressive, competent guy. He stands out as somebody who has stood up to Ms. Willis. But this guy you see on your screen, this dark horse Southern gentleman, comes up and I think gives a master class on a closing argument. I've told this to so many lawyers. Nobody wants to believe me. They think more is better. If you want to be a lawyer, pay attention. If you are a lawyer and you're looking to get your trial skills up, I think pay attention to this gentleman. And if you just love legal movies, this guy could be in A Time to Kill or To Kill a Mockingbird. Probably old enough to be in To Kill a Mockingbird as an extra back then. But no offense, still come on my podcast, sir. But sometimes people think time equals influence. But when you're trying to convince somebody, when I talk to people about giving presentations or public speeches, even if I'm getting paid $10,000 to speak for a half hour, I can lose half the audience the second I go off track. Generally, you have time for 3 points, right? And people stop listening, unless you're telling some crazy story. But lawyer after lawyer gets up there and bores the crap out of people thinking their interpretation is important. Less is more. Every time you do a trial, you tell people, focus on your most important point, not every point. All that being aside, we're going to listen to this gentleman. His name is Harry McDougall, and he's Mr. Clark's lawyer. And he's the last one to go of all the defendants. So, he has the benefit of seeing everybody do their closing argument. But watch this guy. Prepared, concise, persuasive. And I'll stop it as we go through. It's only 10 minutes. I'm going to stop it a couple times. But for anybody who wants to learn the art of advocacy, not the art of acting tough, not the art of consuming time and wasting oxygen, the art of advocacy, Mr. McDougall knocks it out of the park.
Said about the standards that apply to prosecutors. Our appellate courts have said often the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God.
It gives me shivers. I've listened to this a few times to get prepared, and maybe because I know how difficult it is to be great in this situation. He starts off by quoting Caesar. So not usual, but if you drop the ball on a quote, you look like an idiot. But if you nail a quote, people pay attention. So when he gives the quote about Caesar's wife, essentially saying, if you're associated with the government, there cannot be even a hint of improper behavior. He goes back to a very powerful image that makes the judge and everybody pay attention. And then he beautifully ties it into case law that is old. So the older the case law, the more powerful its impact was, because there's tons of cases that come and go. But he essentially ties the judge to saying, look, the Romans knew about it. Our our ancestors found it very important 100 years ago that there has to be an impartiality in the state. So what he's done is brought gravitas to the issue. It can't be dismissed as petty arguing on the lawyer's side who would do anything to kind of clear Trump. He's established gravitas and then expertly reads the prosecutor's oath, right? Without fear or favor, right? Prosecute my duties and be compensated only what is just. That is gold, because Wade testified that he was billing 24 hours a day. And in the Senate hearing today that I just watched, they brought up through Merchant that he could bill $36,000 a month on this case, and he was billing it out at the end of the month on work that could not have been done yet. It shows complete fraud. And this guy has, on one hand at the start, said, this is important, this has gravitas, this is about our country, this is their oath, and they didn't do it. And now he's going to very concisely put his argument out so it can be digested. Pay attention.
The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment, and you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in Williams' case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow.
Okay, beautiful. Biblical references, work in Georgia. He summarizes the case. Way too many lawyers use case law as a snuggle blanket. They're not able to make an argument for themselves, so they just laundry list case after case. And for those people who don't know, when people reference a case, they're essentially referencing a written decision that a judge has given or the Supreme Court has given. But that judge is writing about what the judge heard, what the judge interpreted. And so there's a lot that's missing in case law because there's a 5-week trial. Evidence is given. Some attorneys are good, some are bad. The judge then at the end writes his or her decision, and lawyers love to treat that as law. I don't think it's as law as most people want it to be. I think it's an interpretation of evidence in a trial that can provide guidance. There are some cases that are definitive in terms of some civil rights, and they stand the test of time. So he's not overusing case law. He said this is the principle of conflict. It is shown in these two cases. I don't need to give you 20. Here are the two most important cases where conflict has been articulated. We have the prosecutor's oath. We know what conflict is. And then he turns it all into this is the original sin in this particular case, and he points at them. And I want you to pay attention here to the use of notes. I said that case law can be a snuggle blanket. I think notes are a soother for lawyers who want to read because they're terrified of missing something. And the effective advocate can have sparse notes. The best notes are like 0.4 points. And you got to know your shit well enough that you can stand up there and you look at a judge or you look at every individual in the jury and you tell them what you feel. You tell them what they need to feel. You tell them where they got to go. And if you're so busy reading, calls out corruption, that is like nobody is paying attention to you, but your anxiety is soothed. This guy knows how to get his story across. He's written some notes. He pops down, but he looks up and makes eye contact with the fact finder. It's very effective. He's now going to use another technique of persuasion that I didn't see anybody else do. And pay attention and see if it captures your interest or allows you to understand his argument better.
There are 6 different actual conflicts of interest
Lists
in this case.
work.
Any one of which warrants disqualification.
Make a list.
But collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal and...
Let me just stop here too. Don't take up oxygen you don't need to. So he says there are 6. As soon as it says 6, the human mind goes, okay, there's 6. What's number 1 going to be? Right? The brain is always trying to see if they can figure it. He says the first one is financial. And then he says, it's been covered. I don't need to talk about it. So that's beautiful. He's not wasting time, but he's got everybody's attention. So
political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing.
And I just want to start here. This guy's got the parts, and he's not overselling his points. He's persuasive, but in listing the 6, he's got everybody's attention. The way he's listed them kind of covers the main parts, but you're going to see where he focuses. And so he's not just throwing as much info on the wall as possible. This guy is going to zero in a nice, calm, professional way and make a villain. And so when you're telling a story and you want to convince people that your story matters and you want them to pay attention, a story needs a villain. What is the villain, or who is the villain in this case? Obviously, it's Fani in a way. But this is the first guy who I thought used his intellect to create another villain that I think the judge is going to pay attention to.
On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19.
A very effective use of case law, not overwhelming, but this is often called the best evidence rule, that if you're going to claim something in court on the witness box, you're obligated to bring the best evidence available to you. So you're an attorney, you know, people are saying that you had a relationship that predated the hiring of Mr. Wade. Well, I can take my cell phone and for files that I've used in cases I've worked on, you can download your cell phone. It's called Cell Assist or something. And I can download my communications, bring it to the court and say, hey, here are the records that I have. I can show I'm obligated, if I want to say something didn't happen, I'm obligated to give the best evidence I have at my disposal to do it. What the state's case did here is Fani didn't provide any evidence. They fought giving any evidence, but then she sits in the stand and goes, proof is me just saying it. No, you have to explain why you can't show one ATM receipt. You have to explain where the bags of cash came from. You have to explain why you didn't give your calendar to show exactly where you were. This is an important case for the nation, and you're not given anything, and you have the audacity to sit on the stand and say, my word alone is proof. Like it's BS. And this guy just beautifully and calmly goes, under the best evidence rule, Your Honor, you can make a negative inference that the evidence that would have been available to them was not provided to you to back up their claims. Calm, beautifully executed. And this guy is, we call it patterning. When you want to convince somebody of something. So I might be sometimes a little bit aggressive because I've got a military background, but you have to pattern to your audience, which is hard with a 12-person jury because you got 12 individuals there. But when I'm talking to a jury, I've studied them. When I'm talking to the kind of timid one, my tone, I'll look them in the eye and I'll go soft and I'll go like, you know what's really important here? But when I'm talking to the fighter, but you know what gets me angry here? I'll make eye contact. This advocate, attorney, is on par with the judge, right? This judge isn't going to be convinced by fire and brimstone or exaggeration. This guy is just giving the judge in almost the same vocal tone what he needs to find in his favor. It's art.
As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney. And that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law, from the state constitution down to the county ordinances, imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There is no boyfriend exception.
This is where he takes a little artistic license, but done it with the Southern style of people who want to be reminded of things that don't make sense, with no boyfriend extension. He doesn't get into details, but it's like there's no boyfriend extension. You can't just work around these county rules because it suits you. It's black and white. You're a lawyer. You understand the rules. If you're not following them, there's just a conflict there. That's what he's saying. I also want to bring a point up. Famous quote by Winston Churchill, who is one of the best orators of our history. And he would say, if I have to give an hour speech, I need 5 minutes to prepare. If I need to give a 5-minute speech, I need an hour to prepare. This gentleman has mastered brevity, conciseness, and impact. Whereas when we watch somebody after this, Mr. Abato, you are going to see a word salad of nonsense from somebody who is not prepared. So although this is actually just under 10 minutes, this gentleman's argument, I bet you he spent 6 to 8 hours cutting down to say the least bit possible to be the most impactful. He's doing a great job of not wasting the court's time, and it keeps the judge interested.
The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false, and that it is a false writing. That's an actual conflict of interest between her legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy
That's
train
Mr.
rolling for as
Sato in
long
the
as
back
possible.
to the right there.
His part in the pattern of concealment is the story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and he got on the stand and he lied about lying in the interrogatory.
Okay, more shivers. Call me a romantic. See, Sato's in the back. He's like, I'm just going to be an aggressive, tough lawyer, because that's what Trump wants, right? Trump likes that. Maybe there's something there. This man wins juries, right? He is talking in the language, right? He got on that stand and he lied about lying. Like, it's beautiful. It's got rhythm. That's the beauty of the Southern language. Jerry Spence, any of the great trial lawyers of American history. You need to get tempo. One of the best trial lawyers I ever met was actually an auctioneer in Oklahoma. And you should hear him roll off how he would auction. But when he stands in front of a jury, it's almost like you're listening to a concert. You're just following with the point. And this guy's got it. He's like, he lied about his wife. He concealed it from his wife. And he got on the stand and he lied about lying. And if there was a jury there, everybody would be going, damn right. Ooh, say again. Hallelujah. This guy is a master. I'm just watching the body language of Sato in the back. I don't think he likes that this guy is so good. He's kind of pretending like it's not that good. I'm sure that they're friends. I don't know any of the difference, but he doesn't have the depth that Mr. McDougall does to persuade.
And the lawyers for the DA's office, they just sat there and let him do it.
Beautiful. Listen to this.
They did nothing to correct obviously perjured testimony.
So I'd be careful here if you're an aspiring lawyer. Pointing is seen as aggressive. A judge doesn't get it, but like if you're making a closing argument to a jury, if you're pointing for emphasis, point at the villain, don't point at the audience. Because it can be, nobody likes to get pointed at, because as children, we had our parents pointing at us, and it kind of shuts down some receivers. But he's getting a little worked up here because now he's moving into his kill shot, where he's like, Terrence got on the stand and lied about lying. And then he looks to his left and he goes, and they knew it. They supported him lying, and they're not supposed to do that, right? The DA's office is supposed to protect the truth. And this guy is showing that he's angry about it. So he's been calm. So if you're calm, when you get a little bit elevated, people pay attention. If you're elevated the whole time, you can't turn your dial to 11, insert Spinal Tap movie reference there, because you're only at one level. Let's carry on.
In and of itself, that warrants disqualification of every one of them.
Every one of those.
The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church, I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect.
For those, most of you should know, but Fani Willis gave a speech at a church that was kind of self-promoting. And she bragged that she has a 95% conviction rate. And she made it allude to the fact that because I'm on the case and I got a 95 conviction rate, these Trump people are going down. But at that speech at the church, she actually called the defense attorneys racist, right? So she spoke publicly about a case that will be tried in the public field and called the lawyers on the Trump side racist. Now, I don't think Ms. Merchant is racist. This gentleman doesn't seem racist, but she went at a church, and what is horrific about it, and I think he touches on it a little bit, and I would touch on it a little bit because he made a biblical reference earlier. I would say, we go to church to worship, to be humble, to ask for forgiveness, understanding that we all make mistakes. She went to church and used it as a platform to call people racist who aren't racist, to try to convince the audience in Fulton County, who would be the jury. So it's almost a way of kind of tampering with the jurors who are going to come by saying, I have such a high conviction rate, if I'm on this and I convict 95% of the people I'm facing on this case are guilty. And he goes into this in a way that I think was very compelling.
Attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend.
I wish I could see her face.
That is a disqualifying conflict between her personal interest and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex doctrine on the grounds that she's the DA. The whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing.
Here we go.
There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. So that shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship.
Maybe I'll explain this a little bit if it hurts. First of all, this gentleman is killing it, but he should have a glass of water because he's like licking the lips a lot. But that's what happens when you get into it. It's a predatory thing. Like you're getting into it, saliva goes, and he's licking his lips, which a jury could find a little bit distracting. It's not being distractive. It's not distracting when you have a judge. Privilege was said a lot in this case, and I don't know how well explained it is to everybody. If I consult with a lawyer or you consult with me and you hire me as a lawyer, our communication is called solicitor-client privilege, so that the police can't subpoena my notes of that. It's a very important protection. And in the case of Mr. Wade, Terrence Bradley was his divorce lawyer. So Mr. Wade was saying that Terrence Bradley shouldn't be able to testify because that was privileged information in relation to his divorce. Legitimate in some cases, but because so much of the conversations were about Fani Willis, the judge ruled that a bunch of those conversations weren't privileged. But the privilege rests with Mr. Wade because he was the client claiming solicitor-client privilege. The DA's attorney, the DA's office didn't hire a law firm and have solicitor-client privilege with a law firm and Terrence Bradley with it. And so this guy, kind of the first of them all, says, look, the DA's office is objecting on the basis of privilege that wasn't theirs. Mr. Wade had a lawyer there. So it shows that the DA was acting in their own interest, claiming a privilege that wasn't theirs to suppress evidence that would have revealed the corruption. It's a beautiful, subtle point that I don't think the others caught up on.
And not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "Shall be absolutely clear, there is no evidence that D.A. Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest.
See, that's annoying. If you're an articling student or a junior lawyer and your lawyer is up there crushing it, somebody came up and gave him a note. That note better be very important. I don't think it is, but if you scooch back a bit, he was in a flow and he was like his line. That's another log of conflict thrown onto the bonfire. So he's got tempo, he's moving, and all of a sudden somebody comes up and puts a note there. And what do human eyes do? They get distracted, they look down, they read it, and it's hard for him to get back on it. But we're getting close to his summary of his closing argument, and it's beautiful. Pay attention as we get into this last clip on his use of language and a tool that people use far too seldom, and that's silence.
The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.
Global laughingstock puts a big flag in the ground. This is not just, he says, and he's capturing what's happened this week. It's a global laughingstock, Your Honor. And if you endorse it, you will be part of the laughingstock, right? And you will actually facilitate the emboldenment of conflicts in the future. That is the way to convince a fact finder to find in your favor. And you're going to see that his attack on the DA's office rattles them because they're coming up next, and watch what happens.
Your Honor, there's not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had 5 minutes for rebuttal?
That's fine.
All right, thank you, Your Honor.
So no adjournment granted. When that guy says there's no more oxygen in the room, he just said you nailed it. Everybody listened to every word that attorney said. When you give a closing argument, say less, say it better, tell a story, and be persuasive. Don't consume up everyone's time. That guy nailed it. All right, so Mr. Abato is coming up to do his closing argument, and by way of comparison, I think this is very helpful. He is, in my world, district attorneys are high performance individuals. It is a very sought after job because if you can work in the DA's office, get trial experience, white collar law firms will pay you a fortune because of your influence with the system in terms of avoiding prosecution. So if you get a DA's job, it can be your ticket to ride. Generally, it's very competitive. This guy should be an absolute superstar because he's trying to help the DA stay on the Trump case. Now, compare how he starts, what he does. He actually starts okay, because I think he probably had the beginning of his closing argument done a while ago. But what I see in him is that he's rattled. When Mr. McDougall was saying, these guys are part of it, these guys knew they were lying, these guys acted in their own interest, what Mr. McDougall did was actually make him lose confidence in his own case. And so you can see if he seems like he is being persuasive. Great book by Ryan Holiday says the ego is the enemy. In today's world, working with a lot of young people, I think anxiety is the enemy. I see huge amounts of anxiety in people and professionals these days. And fear, just like what they said in Dune as well, fear is the mind killer. Anxiety and fear makes the brain like far less effective. And you stumble over words. You're trying to think of what you're going to say. This guy is not comfortable with his arguments, probably because he's making stuff up and his argument sucks. But see if he's got tempo, if he's bringing you as the listener somewhere that you want to go, and see if he makes sense. And we'll just get started with it, and I'll come back to a little bit more lessons learned.
Good afternoon, Your Honor. I want to start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations.
Okay, so first of all, I've listened to this 5 times. I still don't know what he's trying to say here. Verbal tics are common. You want to know what your verbal tics are. I always say right. You probably hear me say right all the time. I'm trying to correct that. Should take a drink every time I say it. This guy stands up. Body language is not confident. Seems like he's kind of making stuff up as he goes. But, adverbs are not powerful advocacy. So saying really, right? I think everybody who watched A Few Good Men, I'm going to do a video on A Few Good Men, one of my favorite movies. Your Honor, I strenuously object. It's like, you object or you don't object. He's like, it's a really strong argument. Like, you don't tell a judge it's really strong. You show that it's strong by virtue of your argument.
And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements.
This dude needs to go back to school for advocacy, with all due respect, Mr. Abano. I know you're in a tough spot. He didn't go into the weeds. He went about 10 feet under the ground. When you're trying to convince an audience, jury, board of directors, sales team, judge, the public, you have to start off with your story. People pay attention to stories, right? Think of everything you remember, it's a story. This guy got right into the weeds right away and immediately starts talking that Terrence Bradley didn't impeach anybody because he's on a technicality. Everybody knows Terrence Bradley was lying. So by getting into the technicality of Terrence Bradley as a way to deflect from all of the closing arguments that showed a conflict is professional negligence from my perspective. Just off the top of my head, if I was for the DA and I stood up, I'd go, Your Honor, this is a story about high-powered lawyers, heavily funded, trying to distract away from the main issue that is important to the state of Georgia and Fulton County, and that's whether there was election interference. People may not be perfect when a microscope is put on their life, but the evidence that we've heard up until this point has not got to the point of conflict that would warrant exclusion or removal from the case, because to remove Ms. Willis and Mr. Wade from the case would set back the prosecution at greater cost than good to the state of Georgia. This is a story about lawyers using every tactic possible to try to cut this case off before the election. And even if you find impropriety on Ms. Willis and Mr. Wade's point, it's not at the level required to remove them because the cost is too great. You got to get a story, you got to get a hook on it. So protect the system, protect the prosecution, don't fall victim to them trying to make mountains out of molehills. And then you inspire and now I'm going to tell you, Your Honor, exactly why these are exaggerated points meant to undermine the prosecution of Mr. Trump. This fucking, excuse my language, I know some people complain that I swear 11 years in hardcore military units, the odd swear word comes out, but I think it helps me be a little better strategist and lawyer from time to time. This guy comes out and fumbles like a little kid dropping toys, you know, walking down the hallway, like not even knowing where his arguments are. They're just falling and he's picking them up. And it's a word salad that I think if we read the transcript of this, it would make us dizzy.
Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple of days.
On the internet.
Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley.
Huh?
The way you properly impeach somebody.
Sato is in the back there going, what the heck is this guy saying? Look at his face. He's like, huh?
Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that
Dude,
Mr.
were you not
Bradley
objecting to
testified
every question?
Is impermissible. It is improper.
All right, let's look at Fani.
Because they did not confront Mr. Wade with it.
I think she's like, this guy's making no
That's
sense.
where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words.
No, Ms. Willis called her a
She made
liar.
the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas,
Very heavy
Ms.
chest
Yurt's
breathing.
attorney
She's like, oh, Jesus.
appeared, Mr. Partridge, and he made
My
very
knight in shining
clear on that
armor is
Zoom
wearing tinfoil.
that Miss Yurty had absolutely no knowledge of a romantic
She's
relationship.
like secretly saying,
and
I wish I was
absolutely no
back in
knowledge
Aruba. I wish I
of
was back in
cohabitation.
Aruba.
Those were the specific references that he made. So, what I would
Oof. Look at that
submit to the
squint.
court is those
She
are considered
is
adopted
annoyed at
admissions,
this dude.
that his client has made based on the statements he made because of the representations she made
She
to
made.
him.
He made, that she made, that he made.
I know that sounds convoluted.
Yeah, it
What I would say to
frickin'
the
does
court
there,
is,
brother. It
Mr.
sounds
Yurty told
convoluted.
Mr.
Your job
Partridge
is to not
because
make it
Mr. Partridge
convoluted.
told the court
Wade
she
is
had
like
absolutely no
furrowing his
information
brow
about
here
the
going,
relationship.
what the
She
heck
had
are you
absolutely
talking
no
about?
information as in regards to.
So, but wait, are you making an argument I should make inferences based? Now, these would be attorney-client privileges or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing.
Okay, for a sec, let's stop. This is just a lot of gold there. You notice the judge didn't have any questions for Mr. McDougall. Right, the judge's kind of been listening. He's like, okay, wait a second. What are you trying to tell me here? Because nobody can really make sense. I'm going to give you advice if you're an aspiring lawyer or a lawyer going into trials. You know, if you have to say, I know that sounds convoluted, you didn't do your job, right? Your job is to take the convoluted and make it into as easy to understand story as possible. As Einstein said, to take the complex and make it simple is genius. That's what you get paid the big bucks to do. Not to just meander down various pathways of nonsense and then say, hey, I know that was convoluted, Your Honor. Can you please make sense of that for me? No, that's your job, sunshine. And he didn't do it. But now he's moving into Ms. Yurdy, who is the lady who was Fani Willis's best friend, who worked in the prosecution's office, who didn't want to testify. So she hired a lawyer. This is a privilege they're talking about. She hired a lawyer to say, I don't want to testify. And he's saying, oh, the communications between Ms. Yurdy and the lawyer are privileged. And he's going to go on to say, but she had a reason to lie about Fani. And the judge kind of asked, well, why would she not want to testify if she had a reason to lie about Fani? She didn't want to be part of it. Let's listen to this rock star's answer.
The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent.
Good.
Because
Please.
the testimony of Ms. Yurdy, when she testified, was vague, very little description when asked in a very leading manner. Is it true, or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were fired, or excuse me, you were forced to resign from?
Okay, and this is why this guy sounds meek, right? These, to me, are some of the most dangerous people you come across in the world. I call them kind of the Goebbels type. And for those of you who aren't history buffs, Goebbels was Hitler's political operative. And they're often, some of the most dangerous people in the world are the quietest, who can't use physical force, but they follow rules to the point of insanity, where they will be the orchestrator of mass injustice, and they can say, I'm following rules, and have a win at all costs. He essentially tried to infer that Ms. Yurdy was led in her answers, which he could have objected. Objection, Your Honor. Counsel's leading the witness. And if he would have been successful, he wouldn't have to say it. But he wasn't successful in the objection, so he's trying to undermine her testimony and saying these two were together. I saw them being romantic all the time.
19 into the time you were fired for, excuse me, you
See,
were forced
there
to
it is,
resign.
right there. I played it again for you. This is called dirty pool, right? This would make me want to choke him out. If you ask yourself why there's no objections, it is almost unheard of to object during closing argument. Even if somebody's saying something totally untrue, you say it in reply. But you see how he goes, until the time she was fired up, I mean, she was forced to resign. There is no judge in the world that will be affected by that. The judge will just say, you are a freaking amateur. If you're trying to change my, what he could say is she was effectively fired, right? Because she was told to resign or she would be fired. But for him to make it look like it was a mistake, this is amateur hour. He's got no real argument, and he's trying all these little garbage tactics to try to sound like he's a good fighter for Fani Willis. And we can already see from Fani's face that she wants to eat him for breakfast. And Wade, I think, would use him as a punching bag if he could right now.
From the district attorney's office in March of 2022, she said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd.
Powerful stuff, brother. How about this? Ms. Yurdy would know this because they're using her place as a crash pad. It's like, do you still need the crash pad? Yeah, we're still bumping uglies. So, You know, it makes perfect sense that she would know that they're in a relationship because they're using her place for their rendezvous. Now, you're supposed to, you can have workplace relationships in many organizations. You just have to disclose it and get approved by your superiors. So romance happens in the workplace. If two people fall in love and they're dating, they just tell everybody, hey, we're in this arrangement. Is it okay if we continue to work like this? Sometimes it's not, and somebody has to be moved or not. Now, if you want to keep getting money, you wouldn't tell it. But what Fani Willis and Wade said is they didn't tell anybody. You should tell people if you're in a relationship and there's kind of a contractor relationship going on. They didn't do it. But for him to say that, what's absurd is that Fani Willis, her best friend, knew they were in a relationship because they were using her house as a crash pad is a stretch.
It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, do you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature.
All right, Sunshine, but you get a chance to cross-examine. You want that question asked when it's your turn to ask her question. Say, could you do me a favor? Could you describe the nature of the kissing you saw? You know, I'm going to suggest to you the kissing was just friendly goodbyes between friends. That would be a proper question under cross-examination. He didn't ask that because you say, no, they had tongues down each other's, playing with each other's tonsils. But for him to not ask the question and then try to get the judge to infer that she's not to believe is, again, professional misconduct. It can fall under a rule that sometimes you hear called Brown and Dunn, where if you don't ask a witness a question that you could have asked them, you can't then make an argument that something should be believed. It loses weight because you had the opportunity to ask the witness and you didn't ask the witness. This guy is clown show.
Ask you to frame her testimony from that standpoint when you're
what standpoint?
Addressing her credibility, as the court's going to do with
you didn't
each and
ask her
every
the
witness
question
that you heard during the testimony of all the witnesses during the hearing.
I have to stop there. As an advocate, when you're arguing, I'm going to ask Your Honor to assess the credibility to that witness as opposed to what I just said about her not explaining the kissing that I could have asked her and didn't ask her, as you're going to apply to every other witness in the proceeding. This is word vomit, trying to buy time because he doesn't know what he's going to say. Don't tell the judge what to do. He knows what to do. Suggest to the judge a path of thinking that can lead to the desired outcome. This guy is so nervous right now that he's tied to his notes and he's filling space with nonsense.
I'm going to see if my screen will share.
I would have somebody else responsible for the IT and putting the screen up there. I'm going to pause it and I'm going to move forward because it's painful and it's an hour and a half of pure pain. I don't know how people could actually sit through the whole thing, let alone the judge, but my advice to you if you're doing closing arguments, this happens in business a lot. It's called death by PowerPoint. People put way too much text on slides. If you're trying to communicate with an audience and you have a slide that's full of words, all that the smart people are going to do is read them in 10 seconds and then ignore you for the next 10 minutes. And the people who aren't interested aren't going to read or listen to it because as soon as they see that many texts, they're going to think to themselves, yawn. So visual aids are very important in trial advocacy, but visual aids have to convey or evoke something. What this hammerhead is doing is putting his notes up on the screen so he can read his notes. And notes, amateur attorneys use as a life raft to help them get through a stressful situation. This guy has pretty much written down stuff. He hasn't I think what he was trying to do was organize it when Fani Willis first came in because he hadn't had a chance to finally proofread it. And he's putting his notes up on a screen. He's going to essentially, you insult your audience, whether you're a coach in a team, in sports, or you're a manager briefing your people, or you're a lawyer talking to a judge or a jury. by putting something up on the screen and reading to them what they could read. And I don't know what the criteria is for this guy getting the job. I don't know if he's going to keep it, but he's essentially going to be tied to his notes in a way that makes him completely ineffective. We're going to move forward.
Also, someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own
Bradley is
testimony
vengeful.
Here, sitting before
He
the
lied
court,
for them.
That all he did was speculate, and any information that he had and garnered and then passed on to Miss Merchant was mere speculation. I believe he said that over and over again when asked.
He said it to
if
your
he had
client's
personal
benefit.
knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from
And he said, I don't remember why I didn't say, I don't remember when he was asked why he said they had a relationship, right? You tried to suppress his answers. You tried to suppress his memory. And now you're making an argument to the judge that Terrence Bradley had no memory and you wish he did. But you know what else? You didn't ask Terrence Bradley any questions. He got on the stand and the defense side did it, but the state's attorney didn't ask him any questions. So if they wanted clarification on something, if there was something that could have helped their case, you, Mr. Abato, could have sat at that podium and said, Mr. Bradley, I'm going to ask you a few questions here. I'm going to suggest to you that you have a clear memory of when it started and you're hiding it for this reason. Is that true? No. Is there any reason why you would lie to the court, Mr. Bradley? Well, maybe because these guys threatened me that if I did, I'd never get another job. Mr. Bradley, like he could, if he was interested in the truth, this guy, remember, when you call a witness, you can only examine them in chief. It means you're a little bit more limited in the types of questions you could ask. The best cases are when a witness who's adverse to my client's interest, I'm able to cross-examine. So if he wanted to get Mr. Bradley to sing, he could have made Mr. Bradley sing, and he didn't. But then he stands in front of the judge and has the audacity to say, "Oh, he had no recollection," and so just ignore the fact that he sent a text that said they were together in 2019. Absolutely.
Prosecutor, Mr. Wade, a former judge. You heard from
Former
the 80th
judge.
governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney.
So this is him summarizing the witnesses, and he's making a call to authority. You heard from Mr. Wade, a former judge. Well, I don't think that there's any integrity to that. He lied to his wife about an extramarital affair he was carrying on. He overbilled the state. So former judges are going to fix that. As you heard from a former governor, you heard from the first female district attorney. So he's trying to say this is the first female. As you heard from her dad, who is a lawyer, he's trying to make his argument stronger by saying these people have good resumes, even though the meat of what they said doesn't help his case.
And good standing when he left the practice of law. And what I would submit to the court is that Miss Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Judge is going to come in and hammer him a bit. So we went ahead 35 minutes, and this guy is now going back to Ms. Yurdy and saying, I'm going to suggest that she was inconsistent at best. But nothing about her testimony was inconsistent, right? She said they had a relationship. They said they were kissing. You didn't ask her any questions, but he's trying to infer to the judge, please find that she was inconsistent because she didn't give as much detail as would have helped us without me asking a question. And he's going to infer that she was poorly motivated, and we'll see the judge give him a bit of a ride here.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
Yeah.
I would agree with the court. It's not an evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony
God, I wish I could
And,
see Fanny's
how
face right
the
now. Look at
receipt-
Sato. Stop. Look at him back there. He's like, what the heck are you saying, young man? He's like, so the judge says, that's not evidence, so you can't say it. And he goes, yeah, I'm going to have to go ahead and agree with you there, Your Honor. But maybe I'm just going to vomit some words out here a little bit more, and you'll just ignore the fact that that was completely bogus. Like, Sato looks up. Look at that. We should zoom in on Sato right there. WTF is this guy saying? And he just folds like a deck of cards. You know, he doesn't, it shows that he's not prepared to make his own arguments, right? You should be able to anticipate that if you're going to say something that's bold, that's on shaky ground, that you got a rock solid bazooka to pull out and say, Your Honor, I understand what you're saying, but this is how I countered that. Boom, boom, boom. This guy's
with her testimony.
Willy
in this
Wonka.
hearing. But I would, it's clear that what was represented as to why she would not, have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify. That
So
she
then,
shouldn't
so
be
then
compelled
under
by
that theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive
So
arise?
she was fighting so hard to avoid the, if we're going down that road that you proposed, she was fighting to have, not to come in here and testify at all. And then she comes in here and
big
testifies.
swallow.
Why would she testify the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it is ultimately
Look
when
at
she was
Sato
forced to
again.
testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about whether she resigned or forced to leave, she was fired, she came out and said she was given the choice: you can either resign, but either way you're leaving. You're fired, or you can resign.
She was honest.
In a manner in which, she wouldn't be officially fired, and when she's trying to get future employment, things of that nature. So I would submit to the court.
If my production team, Alistair, if you can do me a favor, insert in this point the Miss USA clip when she's asked about the educational system in the USA and South Carolina, and she's like, Americans as such, like, he actually sounds like the legal version of this clip we're going to play right now.
I personally believe that U.S. Americans are unable to do so because
In a manner in which, she wouldn't be officially fired, and when she's trying.
education, like such as in South Africa and the Iraq, everywhere like such as, and I believe
To get future employment, things of that nature. So I would submit to the court.
it should help the U.S. or should help South Africa and should help the Iraq and the Asian countries, so we will be able to build up our future for our children.
Thank you very much, South Carolina.
But he sounds like a little child who stole the cookies, and you're like, Junior, where are the cookies? Well, the dog was running around the house, and there was milk in the fridge, and I had to go to the bathroom, and so then I went over here, and Your Honor, it's. Look, we can laugh at this, but this is actually reflects very poorly on the state of Georgia, and I think this guy single-handedly has done more damage to belief in the judicial in the justice system than anybody in a long time, because he's in a go-kart at the Formula One, and it's just pure garbage, and he's tied to his notes. So what I want to share with you guys something that I had learned in some special forces units. When you're nervous, and everybody gets nervous. Politicians, Obama would get nervous at every speech. People who are amazing speakers still get nervous at every speech. You never lose the edge. But there's a thing called box breathing that can really help. And box breathing is when you stop, you breathe in for 4 seconds, you hold, you breathe out for 4 seconds, right? Whenever you're feeling really stressed or overwhelmed, they do this in the Navy SEALs, they do this in like every special forces unit. When you feel overwhelmed, like you're going to quit or you're going to lose it, you just take a second, you stop, you just breathe in. Hold and out. Do that 3 or 4 times, totally changes your state. It'll work in business, it'll work in board meetings, it'll work when you're angry at your partner, it works in the courtroom. There's been times where I've been speaking on important cases and I got kind of like a jig in the brain and I stumbled, and then all of a sudden I get nervous, and then all of a sudden you lose your air and you're like, okay, what the heck's going on with me? Luckily, from some of the training, I just box breathe. And you think everybody can tell you're losing it. What people think you're doing when you box breathe is they think you're being thoughtful. So if I ever feel like I'm losing my air, I'll stop and I'll go, and I'll box breathe. And people are like, he's contemplating something very important. Really, I'm just trying to get my shit together, right? And that feeling you get of losing air, that's when you lose the ability to project. Because as you see, when we're nervous, we start to chest breathe, right? And when you chest breathe, you're not filling the bottom part of your lungs with oxygen. And it's the bottom part of our lungs that give us power. Like when we do martial arts, when we do anything, it's like that. Huh. So this guy is nervous as heck. He's chest breathing. He has no air. So doing a box breathing refills the lungs down at the bottom of the tank so that you can now project. This guy's all over the place. So I want to chat with you. If you'll indulge me, I want to share something else with you. Everybody has felt butterflies. And it'd be interested in the comments if you knew what the source of butterflies are before I explain it. But when I learned this, I've given this at a lot of motivational talks to people who struggle with anxiety. When you feel butterflies, it's because your stomach feels like there's butterflies in it. And most people don't know what that is. But when you are not engaged in a physical activity that's important, I think it's like almost 60% of all of our blood sits in our small intestines. Our small intestines, if we stretch out, almost go a football field or whatever. And they're full of blood vessels that are there that when food goes by, they're absorbing the nutrients into the blood. So most of our blood sits in our small intestines, right? Where it's most useful for digesting over hours when we've eaten. But when our body recognizes that we're in a crisis situation, we release adrenaline. We've all heard of the adrenaline rush. And one of the beauties of nature and hundreds of thousands of years of evolution is that when we're in that fight or flight circumstance, our body releases adrenaline, and adrenaline tells our body, take all of the blood that's in our stomach and rush it to our muscles and brain. So when you feel butterflies, what you're feeling is the blood that's in safe storage in your stomach rushing to your muscles and brain so you can kick butt. So I tell people, when you feel butterflies, don't think that's a bad sign. Just say, that's your body telling you, I'm getting ready for game day. These butterflies are putting the blood where it needs to be, in the brain chamber and in your muscles. And I know it might not be relevant to everything here, but that's what butterflies are. Blood rushing from your stomach, your intestines, into your muscles and into your brain so you can perform higher. So whenever you feel that nervousness in the butterflies, just say, heck yeah, I'm getting ready for game day. This is how my body gets ready for game day. It's not a reason to shut down.
That there's absolutely no incentive. An incentive is not why Miss Yurdy's testimony changed, or the state would contend her testimony changed. But it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would.
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to.
This is a beautiful point by the judge.
Exposed to the things that.
Well,
I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of a nature where everybody would be able to watch and learn at what she has to say as it unfolds in the courtroom, And I'd further submit to the court there is reference to.
If you
she
wanted
left
to lie, you
the
wouldn't
DA's office
fight
in text
the
messages that were
subpoena.
submitted, and I
You would
believe
say,
was,
hell yeah, get me in there.
Defense exhibit.
The judge is saying she
39,
fought
that it's
testifying,
because she released
so he
confidential
can't say that she
information
wanted to lie.
in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through
That's a
some other
pity
things.
comment. Look at him, he's like,
Next,
yeah.
Terrence Bradley and
Okay. So you see that? This is like the worry. I don't know where the hell I am. He's like, okay. The judge just revealed a very bad logical argument he made. He fumbled the ball tremendously, and so he's like, hey, like I don't want to rattle you anymore, sunshine. Like let's just get through this. And he's like now scratching his head, and he tries to discredit Willis.
when Miss Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So
Allegedly,
it was
no,
important
he wrote in
to,
text messages.
bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determine to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie.
Okay, so this guy is so ineffective at this moment. I'm going to have my production team insert a clip here. It has profanities, so turn the volume down if you don't like them, because it's full of them. He's essentially saying that Terrence was a liar, even though he tried to stop Terrence from talking. But at the moment, this is such a word salad of nonsense that it evoked in my mind the clip from Full Metal Jacket when Gomer Pyle is trying to get over the obstacle, and the drill sergeant major is at the top, and he's like, Gomer Pyle, what are you doing on my obstacle? Get the F off my obstacle. And we're going to play the clip shortly in there. It's hilarious. It's got a lot of profanities. But at this point in the video, inside my head, I'm screaming, Gomer Pyle, get the F out of a courtroom, because you have no business being here if this is your closing argument on a case this important. Mute it if you don't like profanities. Amazing movie, Full Metal Jacket. But this is what I felt when I saw this guy doing his closing argument. He looks like Gomer Pyle trying to climb that obstacle and is just completely incapable of meeting the acceptable minimum standard.
You climb obstacles like old people fuck. You know that, Private Pyle? Get up here. You're too slow. Move it, move it. Private Pyle, whatever you do, don't fall down. That would break my fucking heart. Quickly, up and over, up and over. Well, what in the fuck are you waiting for, Private Pyle? Get up and over. Move it, move it, move it. Are you quitting on me? Well, are you? Then quit, you slimy fucking walrus-looking piece of shit! Get the fuck off of my obstacle! Get the fuck down off of my obstacle! Now! Move it! I'm gonna rip your balls off so you cannot contaminate the rest of the world!
But what precipitated the soon move.
Now he's talking
Miss
about
Willis
Terrence
to,
Bradley.
What I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Miss Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times.
This is
He
him
said,
talking about Willis's
in
dad.
reference to the questions by defense counsel that were in a and I'm just going to be straight up with the court. They were trying to make Miss Willis a liar. What is how I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but fails. Would be how the state would characterize it.
If you tried to pay me to make an argument worse, I don't think I could do it worse than what he just did. Like, he's essentially saying that the defense tried to make her look like a liar because it made no sense that she would leave the house for her own security because she left her father there and her kids would go there. Like, that's what defense was saying. And this rambling is supposed to be an explanation of how that was proven wrong by the father. This guy is focusing on small issues that do not speak to the conflict. He's almost engaging in a closing argument that's just saying, hey, I didn't like what these guys did.
Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office. And he talked about...
Nobody cares. Lick the lips, buddy.
How he kept cash in his home and why Miss Willis kept cash in his home. And what I would... what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. So there was, I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling.
I'm playing this longer because I want you to see how painful it is
by defense counsel
when you're on the other side.
Gives credibility
if you're a lawyer doing
to the
this
statements that
and
were
you're a
made.
juror,
He further explained as to why
you are like
taught his
saying,
daughter to
please
keep
make
cash,
this bozo
in the
stop.
home as it relates to financial
Nobody
independence
can
and
follow
having a
this
safety
guy.
net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it. Did it follow her? Where she laid her head? And things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations.
I don't know if that was a little runway walk that he did there to try and make it look like he's got his crap together there, but it was very, first, don't walk away from the microphone. That's how you get hurt. I don't know what that was, but the arguments, I'm going to try and move through them because it's painful at its best, but I want to get to some of the more interesting parts.
Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore,
you would know a lot about that, my
if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gay Banks, in addition to Mr. Wade. If she has this grand plan scheme in order to
look at Sato. I was like, did he just say that? Okay, let's stop everything right here. So he says that if the defense attorneys are arguing that she was receiving financial gains from Mr. Wade, that if you believe that, you have to believe that she had a relationship with the governor who was considered for the job but didn't get it. Like, this is a chasm of logic that Evel Knievel could not cross. And this guy is selling it as compelling storytelling to a judge. Like, I don't know if you're sitting at home at night thinking, okay, I'm going to tell the judge that they can't have a relationship because if you believe they have a relationship, she would have been having a relationship with the governor who never got the job, who she never had a relationship with. This is criminally negligent.
Case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor.
Look, if that was at the beginning of his opening, it could have impersonated a proper start to a closing argument. It just seems like he's making it up as he goes along. I don't know what his notes actually said. I'd love to have his notes beside Terrence's doodles. We're going to move forward. I think you can tell the stress he has about Fani with the next clip I'm going to show you. Okay, we just skipped through another 20 minutes of pain. Same thing. No variance in tonality, sleepwalking tempo, umming and ahhing, festival of lip smacking and nervousness. I can assure you there were no more runway walks in what we skipped over because we would want to see that. But now, somewhere in his notes, it probably said, okay, now let's kiss my boss's butt.
That in a house she didn't live in anymore, she had to pay for a safe house. That her home was vandalized.
Crash pad.
And there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety and her life is something that was testified to. And the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times.
Sado, it's just his own show.
Occurred. The stigmatful nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Ms. Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from at HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office.
Oh my God, are you the campaign manager, dude, or are you like
what
the
was
attorney?
shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case.
Is anybody following this? Like he puts emphasis on the word of. Okay, if you're going to emphasize a word, you want it to be in the active voice, not, and he gains benefit of. Why would anybody want to pay attention to the word of? Like, dude, you're supposed to be trained in trial warfare. And you are, I don't even know what type of military to compare you to based on like the units I've served on, but like we would all pray to go to war against somebody who is so inept.
The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, they're based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed.
And the Iraq, everywhere, like such as, and
Yeah, at some point we feel like we're rubbernecking a car accident on a highway, and we're just looking for dead bodies, because watching this guy it's now redundant. But this final argument he's essentially saying now, as one of his arguments, that if she wanted to make money off of this case, she wouldn't have only indicted 19 people, she would have indicted all 32. It's not a strong argument, because really, if you have a high conviction rate, you want at least a chance to win. 32 makes it harder to navigate. But you also have to keep in mind that two things can exist at once. She could be grafting off of the case, but I also believe that there are Democratic Party operatives in this office. And what we saw today in the Senate hearing, that Wade and Fani Willis spent time in the White House meeting with the Attorney General. So they're essentially, I don't want to say colluding, but they're partnering and meeting the Attorney General for the government, probably to get an update on this case, which is meant to disqualify a presidential candidate who will likely beat Biden. So the two things can exist at once. She could be making money off of the case, but she could also be under some instructions, make sure this case gets in front of a jury before the election. So the argument is nonsensical. Everything he said is nonsensical. I'm going to move to his closing so we can wrap this up, and hopefully we can all kind of never have to watch something this bad again. All right, ladies and gentlemen, he got his 2-minute warning note, and there's been a lot of buildup. I can tell you're feeling the energy here. You're waiting for the climax, the Deuce de Machina to come out here and wrap this up, to develop the killing blow to the defense attorneys. Here is Mr. Robato's final shot across the bow.
Statements made by Ms. Willis, and it involved a statement that the words fake electors were said by Ms. Willis, and he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct.
Lick lips, lick lips, lick lips. Yeah.
And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne.
This is not true. Sato gets up after and says she called them all
not even
racist.
close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as two unrelated, to this case, public officials criticized the job that she was doing. And I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain, was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with, kind of how the state started the argument, is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. An actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
Oh my God. Look at her. Look at her. She just walks away. She doesn't even look at him. She's so disgusted. So Mr. Sato comes up and says, look, he was wrong about 100 things. He's got a strong voice. People listen to him. He talks with authority. It's not always convincing to some audiences. But if we just step back for a sec, he finishes, she doesn't look at him, and she runs out. Like, I'm telling you, when I make a closing argument, I put my heart and soul in it. And when I sit down, usually my client hugs me, even though I feel worse for them because they know I left it all on the frickin' table, right? Like, I leave my heart on the table when I'm fighting for their life. And this guy it's like a painful long breakup. Like, you're trying to get off the phone with somebody who's like, thinks more sentences. Like, I can't even come up with any more literary examples of how bad it is other than there should be an Uber with a one-way ticket to a glue factory for that guy from a legal perspective, because it was horrible. Look, what would have been effective is if you would have taken note of the 6 points that were articulated as grounds for conflict and addressed those 6 points and argued why they didn't matter. But in summary, I think I actually may have done a disservice to Miss Carolina by equating, because I think how bad her statement might have been at that Miss USA pageant. She's not an advocate, right? And she did her best. This guy is supposed to be the best of the best. And I think I'm going to apologize to Miss Carolina right now, because this guy is multitudes of factors worse than he is. In closing, I think the defense team did a good job. Let me just say this. Ashley Merchant should get all of the kudos because she dug this case. She dug into the details. She did the motions. She did the subpoenas, and she uncovered the treasure that will result in the success. So don't judge her too hard on the comments because she wasn't the best cross-examiner. She did an amazing job. She's the reason why I think they're going to be thrown off the case. Mr. Sato was great at cross-examining the witnesses and making them look like liars. And Mr. McDougall knocked it out of the park with a closing argument that should be taught in law schools of how to do a closing argument. And unfortunately, Mr. Abato, if I was a law school professor, which I would never go to a law school and teach, I do teach trial lawyers, I will probably be using this video to teach trial lawyers how not to do a closing probably 100 more times. It's embarrassing. But a masterclass in learning what to do and what not to do, and how you can enjoy a message and how you can hate a message. And in summary for this case, there's lots more to come. But when you're assessing the credibility of witnesses, I always go back to Mark Twain. It's better to tell the truth, because when you tell the truth, you don't need a good memory. It's easy. Till next time.